of all, their planned marina recreation area is also 150 feet away from existing homes. And a few more words about the marina area. That includes a 2,500 square foot building, which includes a deli and a restaurant based on the developer's plan. Now, 2,500 square feet building for a 24-slip marina basin? Really? This sounds like a smokescreen. The building supports a nearly acre-and-a-half recreation area, which is in blue up there, that will be used by the 1,000 residents, hotel guests, and employees of the development. We will likely see a tiki hut-type environment within 150 feet of existing residences. How can anyone say that this is compatible with the existing residential community? I ask the Planning Commission to reject this zoning change. Thank you.
Thank you.
Karen Turnbull, 3606 Tohey Court, Gorda, Isles. I've lived there since 1991, 25 years.
And you've been sworn?
I have been sworn.
Okay.
I do not live directly across from this proposal, but I live within a mile of this proposal. And as has been mentioned earlier, noise does carry here. I hear trains. We all hear trains go by. We heard the speedway when it was in operation. We will all, not just those immediately across from this place, we will all be negatively affected by this proposal. I concur with all the comments that have been previously made, including the issue of trust. Before I purchase property, I always take very much care to see what the future proposals are for the area around my future home in which I'm going to invest many, many dollars and years. I believe I'm very disturbed by the fact that this discussion is even taking place. I am concerned about safety. I'm concerned about traffic. Traffic has been addressed. I have not heard traffic during tourist season being addressed. This area is different than a standard traffic model because it quadruples during certain periods of the year. So if they've averaged summer and winter, it's meaningless. In addition, we had a hurricane issue. I'm concerned about that. I'm surprised we're even allowed to get away with what we have now, truthfully. In addition, safety, ambulances, fire trucks, everybody. Left turn lanes is going to be accidents. It's going to be more policemen. I worked for the school system here, Charlotte County, 23 years. Maybe the hotel guests or the condo owners won't need schools, but the massive influx of employees for these operations will need schools. Vehemently opposed to this development, and my request would be that not only you disapprove this development or this zoning change, but if there's any way possible to permanently place a thing in there saying that this can never even be proposed again, that I would support. Thank you very much.
Thank you.
My name is Donald Tao. I live on White Island, Philippines, and I have a very specific concern.
Sir, you've been sworn, sir?
Yes, I have.
Okay, thank you.
I have a very specific concern. I'm, of course, concerned about noise, lighting, etc., etc. My condo looks immediately across the canal. The proposal of 25 parallel docks, which would be, again, immediately across from me, has me concerned. First of all, the Corps of Engineers has said that mangroves cannot be disturbed. What will be the access to these docks? How will dock owners or not, I guess not documented, the boat owners get to their boats. That has not been clarified. Perhaps the attorney representing the project could address that question. Thank you.
Thank you, sir.
Hi, my name is Jim Quinn. Live at 615 West Marion Avenue, and I've been sworn.
Thank you.
I moved here in 1997, and shortly thereafter, there was a controversial project called Lashley Park that people were outraged because Lashley Park was going to be developed. Thank God it got developed. Thank God we have that nice waterfront property now. Vivante, another project. People were outraged. Traffic was going to be crazy. Congestion. It's the nicest condominium project in the area, and the traffic really isn't that bad. You know, I've been a realtor in this area since 2004. You know, I've respected all your opinions, so let me express my opinion. I've been an eyewitness to the developer and the effort that he's made to make this project work. Somebody mentioned they don't have a vested interest in the community. They have a significant financial investment in this community. They have 3 employees currently in town. They've been hiring all these experts, and as much as I respect your opinion or your ability to express your opinions about this project, honestly, I put more faith in the experts that do this on a daily basis. And when I listen to Mrs. Tubbs recite the report from the city, it sounded to me like they met all the expectations. So I don't see how you could possibly vote against this project. And I'll be very disappointed because if you allow this project to go forward, I'll bet anyone in this room that years from now will be looking back on it as one of the most successful projects in the area, just like Lashley Park, just like Vivante. And we all want economic development in the area. We want to have some investment in the area. But then when this comes up, nobody wants it in their backyard. Do we really want to be standing here a couple years from now talking about a 200 or 300 unit single family house that has no personality? This project is a gem that most other communities would love to have in their community, generating tax dollars. So thank you for listening to me. I'm sorry you don't agree with me, but if you guys get this shot down, I hope you get what you want down the road.
Thank you, sir.
Don Sabatini, Punta, Gorda. I have not been sworn.
You haven't been sworn?
No.
Raise your right hand, sir. You solemnly.
Yes, give Mark. Yeah, go ahead.
If anybody else was not sworn earlier, and you think you might speak, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in today's proceedings?
Yes, I do.
Thank you.
I'm a little concerned that the so-called experts are really not experts. I've witnessed the eagles for over 2 years in those trees, so that concerns me. The comments about Vivante and Lashley Park, they're not in residential areas, so I don't feel those are pertinent comments. I'd like to ask if the person from the Planning and Zoning Commission is still here. Have we taken the proposal and verified all the data and numbers?
Excuse me, sir, you have to direct your comments to the board.
Well, I'm sorry, has anyone taken the proposal and physically gone out and measured and validated all the numbers and the data in the report? Has that been done by anyone?
No.
That's directed to city staff.
I thought this was an open discussion. I'm asking.
No, it's not.
Okay. So how do I get the answer? I have to go to
address the board.
Go ahead. Proceed, please.
Can the board ask the Planning and Zoning Commission if they have actually physically validated all the information in the report?
You can, if you want to say that it's your opinion that they have not, that's fine.
It's not. I'm asking for clarification.
Yeah, we'll direct the question both to staff and also to any of the expert witnesses that have testified earlier.
For the record, Terry Tubbs, Urban Design Manager, and I have been sworn. The experts that have prepared these reports are experts in their field, and I rely on their expert abilities to do those studies.
My question in all respect was, did anyone from your department or your expertise, not the experts, but you that represents the city, has anyone validated all the information in the reports? Physically gone out and measured and confirmed?
No, I have not physically gone out to the site.
Thank you.
Excuse me, may I direct a question to you?
Yes, sir.
Have you ever stood on the moon?
No.
No. Do you accept input and testimony from an expert?
I'm not sure where the question is going, but I came up here as a citizen to ask a question. My question's been answered.
Thank you.
And I just wanted to close with, again, we need to be concerned with this. Is the person developing this property is here to generate revenue for himself. Okay? That's really why they're developing this property, is to make income.
Good afternoon. I'm Bradford Gamblin. I have been sworn, and I am also a resident of Punta Gorda Isles, and I live on Almar Drive, which happens to be an extension of Rio Villa, which I now learned today is going to become the main thoroughfare for bicycling. I will point out that it is somewhat like Kiasta, and that it is narrow. It has a bridge on it with no sight distance, and I'm not sure we're happy to share our road with the bicyclists. I did want to point out this is narrower even than Kiasta by quite a bit. Another thing mentioned, the proposed hotel at this site is actually bigger than the two major hotels downtown Punta Gorda put together, just to give you a perspective of the size of the proposed hotel. And I also have a question, because they so emphasize that D-rated roads are good, I gather. Then why do they have A, B, and C? And I'm asking you this question. Is D-rated really what we want? Is that the Kiasta adequate as a D-rated road? Is it really good that we are going to be adding a high-density development and the traffic from it to that road? I pose that question to the board here. There's been so much said, the eagle nesting and all of the other things that are relevant to this. I really appreciate everybody's time. I have to admit, I admire the board's ability to sit there for 2.5 hours and not have to have a restroom. Thank you.
Thank you.
My name is Rebecca Rasmussen. I live on 1639 KCT, and I have been sworn. I apologize if I'm not totally coordinated on this, because I hadn't planned on speaking, so thank you for listening in advance. I would be happy if they built a commercial component downtown. That seems to be fitting with what your long-term plan was. I have no objection to the residential component, but I'm totally confused on how MediSpa is going to make it out there, as well as a hotel. It's far away from anything. It doesn't fit with the rest of the area, and it just seems out of touch with the MediSpa in this area. If you're Miami, Orlando, Sarasota, somewhere else, but not here. It's in an area that it's not fit for. I also question the traffic study. I know that you made a comment that the experts are the experts, and the prior lawyer made a comment about that the data is the data, but the inputs are what produces the results in the data. And as a scientist, I'm really intrigued how you cannot be increasing traffic more. I did math just sitting there and reading through the plan, And I come up with over 590 trips a day because it doesn't seem like you've counted the workers, of which there's got to be at least over 100 more workers going in and out daily. And if you count rotation shifts in a restaurant, there's got to be more than that. As someone who travels a Kia saw every day, the traffic is terrible. And as the prior lady pointed out over here, if you're in winter, it's terrible. It's nothing, anything like summer. So I'm very concerned about the traffic patterns and the comment that the data is the data. Well, traffic also affects quality of life. And I was very appalled at the statement that from the developer there that doesn't foster good relations to say that it's facts, because I don't believe it is. The services are at least a mile away because as much as I admire 7-Eleven and Circle K, they don't qualify as full services to me. The restaurants downtown already struggle to make it through the summer months. And now to put in a restaurant in a hotel that charges $200 to $300 a day, it's got to be a high-end restaurant to attract people to go back there, which means more traffic. And I just struggle how they're going to survive through a summer where our downtown restaurants, which are excellent, don't make it through easily. And so as a person who lives in that area and is affected by traffic every day, I appreciate the struggle that you're going to go through, but the scare tactics that this is going to scare away developers is crocahooey. It's absolutely ridiculous. What needs to be done is the developers have a clearer idea of what's acceptable, and this isn't acceptable. I ask you to turn down this variance.
Harry Kreutzmann, 3652 Aruba Court, so I'm not immediately adjacent to what we're discussing.
Speak a little closer to the mic, sir.
Harry Kreutzmann, 3652 Aruba Court. I'm over towards Punta, so I'm not immediately adjacent to the area we're discussing today, and I have not been sworn, so how do we take care of that?
Anybody else? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Absolutely. Okay. Only want to make one point here today, and it tricks into my background. I'm an attorney, New York, Connecticut, state, federal appeals. And in my career, I've dealt with many, many experts, thousands of experts, both against me and on my side. And the simple point I want to make is we have one line of experts who I believe represent the applicant. And what I simply want to share with you, and as I said to your Eagle expert over there before, you can simply look in the back of ACTA, American Trial Lawyers Association monthly magazine, and look at the classified. You can buy an expert to say anything you want on either side, and sometimes the same expert will change sides depending on who's there. And I've actually had that happen in court where an attorney came over to one of my lead people and said, "What are you doing in the gallery here?" And she said, "I just stopped in." And he said, "Well, thank goodness, because if your company had an interest in this case, I would have testified differently." So I simply wanted to share that and make sure everybody keeps an open mind. Thank you.
My name is Jane Cunningham. I live at 2140 Via Venice, and I'm really nervous, so I'm sorry. Our property is nowhere near this development, but I am here for my friends and neighbors. We all came to Punta Gorda for the same thing, and we're all looking at you to make sure we get what we came here for. I do want to ask a question of Mr. Counsel. I don't know you, sir. I don't know how you're appointed to your position. I am pretty new to Punta Gorda. We built a home here. We've got over $1 million in our property. You don't seem like you like your job today. You are very contentious to the people of this city who you serve. I find this very enlightening, and perhaps if you don't enjoy your duties and cannot speak with respect to the citizens of this town, you might need to look for something else to do.
My name is
is Carolyn Freeland. I have been sworn. I live at 240 Da Vinci Drive in Punta Gorda. I am a past council member, a past vice mayor, and a past mayor of the city of Punta Gorda. And I was extremely excited to see this very unique proposal. Very unique for Punta Gorda. And then when I reviewed all the comments from staff, I was also very pleased to see that it was consistent with our city's comprehensive plan. And I know that there are individuals here who, perhaps many of you, who do not want this proposal to go through. And based on the comments today, it probably won't. But we really need to be careful about what we wish for. The gentleman talked about Vivante. That property was owned by a developer who wanted to build 60 mega-million-dollar properties. Because of objections from our citizens, particularly at Colony Point, the developer gave up, sold the property, and now we have Vivante, which is lovely, but it's not finished yet. So we have 500 plus units. We probably have another 500 plus units coming in, increasing the traffic here in Punta Gorda. I think we just need to be careful not to take a look at, again, what might be possible. I was pleased to see that the developers and their attorney have worked to address so many of the concerns that our population had, with the buffers that were being put in, with all of the other things. And I believe that between our staff and our city council and this planning commission can make recommendations to assuage the concerns of our citizens. I agree with you. You know, we all came here because of Punta Gorda, but we have an opportunity for a very different kind of special place. Tarpon Cove on Marion Avenue, that was rejected. I mean, citizens came out and didn't want that particular development, and it's beautiful. And now residents are moving from their homes to move to those condos. So just we need to be careful about what we wish for. And I want to thank, and I would like to apologize on behalf of my other colleagues and residents for not respecting our experts. That'll be it.
Thank you. This is a public hearing. Anyone wishing to testify, please approach the podium. It's a public hearing. Second call. Anyone wishing to testify, please approach the podium. Third call. Anyone will? State your name. Have you been sworn?
My name is Bill Leach. I have been sworn. I would like to state that we are here today, the majority of us that are here today, that are obviously opposed to this development, this type of development, in no way would oppose this gentleman from developing the land the way it was intended to be developed. There's not an issue with that. We know something's going to happen with this property. We just don't want high-density housing. We don't want commercial enterprises, nor do we want anything that resembles a marina. That's all I have to say. And I want to thank you for all the time that you spend considering these proposals and what you've done in the past.
Good. Thank you.
Is someone allowed to make another comment?
What?
Can I talk 2 times? Okay. It's Karen Turtle again from
Go, if you make it short, please.
Okay, thank you. I just wanted to also say that it will not be in the best interest of this city or realtors or property owners when a vast number of us exit Punta Gorda Isles. And I will say that if I have to listen to bars and restaurants until 7 p.m. at night, even one day of the week, I will not stay at my property. That would not be in the best interest of the city, the tax base, that will not draw new residents to this area. And I think that needs to be thought about also. In addition, Vivante and Tarpon Cove and these other things are open to the public. Anyone can live there. Anyone can, whoever lives there, use those facilities. They also don't have noise. They don't impact the neighbors. The things that this new development has is strictly for their own people. So not only do we get all the negative effects, we get no positive effects whatsoever. If we did want those anyway, we would have moved somewhere else. Thank you.
Thank you.
James Vandenberg. I just have one quick question for the board. Something that I don't think has been addressed, and that's the timeline of the project. How long will it take this project to fully develop?
You can direct that question to sure.
Development will likely occur build out between 5 and 10 years. We used a 5-year build out to be very conservative in the traffic analysis. In other words, the traffic coming on sooner rather than later. But it's likely a 5 to 10 year build out.
Thank you. This is a public hearing. Anyone else wishing to testify? Second call. Anyone wishing to testify? Third call. Anyone wishing to testify?
Move to close the public hearing. Rebuttal from the applicant.
That will go into the final close now. We have a motion and a second to close the public hearing.
The applicant's rebuttal is part of the public hearing.
I'm going to quickly bring up Ian Vincent to once again address certain issues that were raised regarding eagles and the environmental aspects, and then I will make some concluding comments.
And I think I forgot to say that I was sworn the first time, but I was. Real quick, Ian Vincent Associates.
And would you now swear under oath that the testimony you previously gave, you're now adopting as your testimony under oath?
Yes, I will. Thank you. To Ms. Matthews and other people who mentioned the eagle, maybe I didn't say it clearly the first time. I want everyone to understand. We acknowledge that there has been an eagle on that property. The eagles likely utilize the property. The thing to understand is that protection for eagle is limited to active nesting sites in the area around them. So please don't think that anyone think that I've gotten up here to say there's not an eagle ever on that property. We've acknowledged that they are. The critical thing to remember is that we are adhering to the guidelines that state and federal wildlife agencies require us to adhere to for the buffer zones around the nest. Also, Ms. Matthews, relative to wood storks, you're correct, they probably are there. If you'd like, I have my suitable foraging habitat analysis that I completed. It's about 30 pages. There was a review by the Fish and Wildlife Service, and their determination was that there would be no adverse impact to the species. Final thing, someone did ask the question, it's actually a good question, how are the boat owners going to get to the parallel docks? As it's been pointed out, our current site plan does show single family along there, the previous site plan, which is what the parallel docks originally lined up to. Our original plan actually had a boardwalk through the mangroves every other slip. We haven't really had this conversation, but in looking at the proposed site plan in this development, I believe we can probably cut those by about 80%, and there will just be a couple going through. So actually, when we speak for the applicant, I think there'll actually be a little reduction in what our permanent impact was. And other than that, that's it. Thank you.
Thank you, Jerry Wax, the recording law firm. Oh, not at all.
And I don't know that I've stated, but for the record, David Levin, City Attorney. There has been some discussion regarding your Corps of Engineers permit and certain aspects of that permit that require wetlands to be placed into some sort of present reserve.
Yes.
Was that requirement to put property into a reserve a requirement of the issuance of the permit, and were those areas already placed into a preserve?
They have not been placed into a preserve, and I don't want to go into a story about Army Corps permitting, but anytime you deal with wetland impacts, whether the Corps or Swiftman, I guess I'm going to, you have to justify any impact that you have. You can't just say, I want to fill in that wetland because I want to fill in that wetland. You can justify it for access reasons, for economic reasons. So to answer your question, the preservation of those wetlands was tied to the Army Corps and SWIFT coming to the wetland on the property was permitted to be filled in. A lot of times it doesn't make sense financially, it doesn't make sense from a time standpoint, but it is untrue for someone to point to that map and point to that line and say, you cannot impact those wetlands, because just play fairy tale land. If you deny this and someone else buys the property and they come back to me and they say the only way we make it work is to impact everything, and they have a justifiable argument, we could impact everything on the property. I'm not saying it would be easy, God, I don't want that project. But it is not fair for anyone to point to those preserves and say that that's not potentially developable land, because everything is potentially developable.
And just to be clear, to the answer to my question, is that the placing of those wetlands into a preserve would only have been required if you went forward with development of the permit.
That is absolutely correct. I believe, so I'm under oath, I'm not going to guess, but I believe we have 30 days. It's something like 30 days from initiating the first impact that we have to begin the well enhancement and preservation plan. So if we were to go forward with any of the Army Corps impacts, that's what would trigger the need for preservation of those wetlands.
Do you know what the expiration date of those permits were?
The Army Corps permit, I believe, was issued early 2015. It might have been the end of 14. I believe it was a 5-year permit.
So they're still active?
Yeah, both are still active. The SWIFT permit is a little bit older, but I would anticipate that we'll renew it, and that's a relatively simple process to renew.
Thank you. Thank you, Mr. Chairman.
Thank you.
Again, Jerry Waxler, the McCrory Law Firm. This is a request for a planned development rezoning. And there seems in the audience not to be a complete understanding of what a planned development rezoning is. This is not a straight rezoning. This is a rezoning based on a site plan, based on a list of uses, and based on and able to be conditioned. That means that if our site plan shows condominiums or a certain number of condominiums or a certain type of use, for instance, we show a 2,500 square foot building adjacent to the proposed docking facility, and we have listed the uses and we've stated that those uses must be internal to that building, we cannot put seating outside of that building, because we expressly stated in the plan that no seating would be allowed in terms of there's not going to be any restaurant service outside of that building. It's not smoke and mirrors. We can't do it, say one thing and then do another thing, because we are limited to what is shown on the concept plan and the proposal that is before you. So I wanted to be very clear about that. We do not increase density on the site. I heard that over and over again. As Ms. Tubbs indicated, density is calculated based on the entirety of the site. It's done that way for every project that has been developed within the city of Gorda. This project is being treated no better, no worse than any other project, just the same as every other project. And by that calculation, we are decreasing density on the site, not increasing density on the site. There are questions about traffic. Traffic is calculated based on peak season, peak hour. So when looking at the numbers of traffic that is generated, it takes into account, it doesn't do it based on the summer. It is based on the most traffic that can be generated. Peak season, peak hour, i.e. rush hour traffic. The numbers come from the IT trip generation manual, which was testified to by Mr. Fellows, and also incorporate a growth factor. So it anticipates growth within the community, the vacant lots now growing over a period of time and contributing traffic. All that is done according to the accepted principles of traffic engineering, and Mr. Fellows, as he indicated in his testimony and in his resume, is experienced and an expert in that field. The docks will require, we've been told by staff, a special permit, as will Marina, so we'll go through a process for that. But I do want to point out, because I always find it curious, that when all the condominiums developed along White Ibis and Purple Martin and put in their docks, where was all the concern for that narrow canal, and where were all the people saying they should be allowed to have docks? If you do not allow, or say that 49 docks for a 106-acre property is going to create excessive traffic on that canal, then I expect to hear those same concerns raised when all of the individual undeveloped lots that feed onto that canal put in a house and make a request to put in a dock, because their right to access that water is no greater than the right of this property. And in fact, relative to the number of units we have, we are seeking to make a far less impact on that canal system than those single-family homes, which will be 1-for-1, one home, one dock, a far less impact than what those single-family homes will be. Now, this hearing One of the people that testified said that they implored you to do the right thing. This hearing is not about doing the right thing as determined by the residents. And it's not about approving or denying based on the will of the people as expressed today. It's about doing the right thing by approving or denying the will of the people as expressed in the comp plan and the land development regulations adopted by your elected representatives. It's also about basing your decision on competent substantial evidence as presented by experts or fact-based testimony presented by non-experts. Well, you didn't hear a whole lot of fact-based testimony presented by non-experts. You heard the correct designation of the existing zoning. The other things you heard were primarily opinion evidence, and opinions are not facts. The only expert testimony before you were that, number one, this project is consistent with your comprehensive plan. If you don't believe my experts, that's fine. That's expressed in your city staff report. That it is compatible with the surrounding neighborhood, also expressed by the city staff. That traffic will be within adopted levels, and that traffic has been verified by our engineer, and staff has reviewed those traffic calculations, although they have not independently reviewed the numbers. But I will point out that all the experts you heard from today, in addition to being credentialed, are all licensed professionals. Licensed professionals do not maintain their licenses by lying under oath to local governments. The information that they presented to you is expert testimony. It is factual and accurate expert testimony and should be treated as such, unless you have any evidence to the contrary, and you do not. The right thing to do here is to consider all the evidence and testimony that was presented to you, to siphon out which was expert testimony, which was fact-based testimony, and to make your decision not based on numbers. Zoning is not done by referendum. It is done by evaluating a project against the adopted standards. By all standards adopted by this community, this project is consistent, is compatible, does not generate traffic beneath your adopted levels, and will be an asset to the community. And as such, I ask that you recommend approval. Thank you.
Thank you. Thank you, Jerry. Board comments.
Motion to close the public hearing.
Yes. We have a motion to close the public hearing. Everybody in great decision? We have a second. Second. Everyone in favor of closing the public hearing? Opposed? Carries unanimously. Okay, now, board comments.
Anybody want to start?
Do you want me to go?
Sure.
Do you want comments or should we just get it on?
In the absence of comments, do we have any motion?
I'll make one.
I have comments.
Go ahead.
I have comments if no one else does. I'd like to just say I am all for commercial development when it enhances the lives of our citizens. I do not feel this project is consistent with the city, the comprehensive plan for the city. I do disagree with that statement. I don't believe it's harmonious to the surrounding neighborhood. I don't believe that it's going to adequately prepare the roadways for the increased traffic. I respect the fact that professionals did these studies, but I do not agree with what I've read. I do not agree with the fact that that it's in any way consistent with the comprehensive plan for the future land use portion of the comp plan. I feel it's our duty to listen to and to respect the citizens who have made their voice heard today. As we work for the citizens, we are appointed by the City Council. For those who had that question, we are appointed as members of this committee by the City Council. We do not get paid for this job. We volunteer our time to the city. I do believe this is going to negatively affect the quality of life for those who already live in the city limits, especially those who live in PGI and the surrounding communities that live on feeder streets off of Akiastock. I have talked with several hundred citizens who live in Charlotte Park, in Buttonwood, and other surrounding communities, as well as people that live in PGI, and I am adamantly opposed to this project going forward.
We'll entertain a motion.
Based on the evidence and testimony presented at this public hearing for item PD-03-16, I find that this request is consistent with the City of Punta Gorda comprehensive plan, and we recommend the City Council approval of this request.
Was there any discussion regarding the staff's recommendations?
You're correct. We want to include exactly what the staff recommended, the conditions at the end.
That was Mr. Loma.
So we have a motion and a second. Any discussion from the board? All in favor of the motion?
Aye.
Aye. All in favor of the motion, please show with a show of hands. 3, 4, all opposed? Nay. 4, 7, 4 to 3. This will go forward then to the City Council. Thank you all for coming and participating. We want to resume the hearing. Okay, let me final agenda item after this marathon meeting. This is SB-03-16, a resolution of the City Council of the City of Punta Gorda, Florida, vacating certain portions of Maud Street, Gorda Esplanade, Maud Park, and Crosby Park in the City of Punta Gorda, Charlotte County, Florida. More particularly described in Exhibits A1, A2, A3, A4, and A5, and providing an effective date.
Good afternoon. For the record, Terry Observer Design Manager, and I have been sworn. The following findings can be drawn concerning this request based on the information submitted by the applicant and attached herein, and upon written provisions of the City of Punta Gorda code pertaining to this type of request. Finding number 1, Fisherman's Village is a commercial multi-use development constructed in the City of Punta Gorda, Florida, on lands within the subdivision plats of Trabute and Punta Gorda, recorded in Plat Book 1, page 1, and Plat Book 1, page 23 of the official records of Charlotte County, Florida. Finding number 2, ATA Fishville, Florida, LLC, is a Florida limited liability company. The owner of Fisherman's Village plans to substantially enlarge and enhance Fisherman's Village on various lands adjacent to and within the existing Fisherman's Village project, all of such lands being located within the plat, a description of such lands being attached hereto designated as the property. Number 3, ATA is obliged, pursuant to that certain acquisition agreement between ATA and the city dated September 2nd, 2015, to petition for the vacation of certain portions of Maud Street and Red Esplanade. Finding number 4, there is no evidence of Maud Park or Cosby Park ever being accepted or used for park purposes by the city, and Cosby Park and Maud Park have been continuously used and occupied by the city for non-park purposes for over 30 years. Finding number 5, portions of the property have been previously vacated pursuant to vacation resolutions recorded in Official Records Book 18, page 122, Official Records Book 468, page 313, Official Records Book 582, page 273, and Official Records Book 582, page 1877, all in the public records of Charlotte County, Florida, and are incorporated herein by reference. Finding number 6. Additionally, portions of the property have been occupied by buildings owned by ATA and its predecessors on lands owned by the city for over 30 years. Finding number 7. The city has acquired title to portions of the property by deeds dated July 12, 1974, recorded in Official Records Book 475, page 631, and September 4th, 1974, recorded in Official Records Book 470, page 129, August 29, 1978, recorded in Official Records Book 585, page 1507, and October 10, 1978, as recorded in Official Records Book 586, page 510, all in the public records of Charlotte County, Florida, and are incorporated herein by reference. Finding number 8, portions of the property released to ADA's predecessor under a lease dated July 17, 1978. Based on the findings presented above, the Punta Gorda Urban Design Division offers the following conclusions, leading to its final staff recommendations. Conclusion number 1, the portions of the property comprising Mod Park and Cosby Park have been continuously in city ownership under the control of title and lawfully used by ADA and its predecessors pursuant to the lease for generating public revenue and not for public park purposes for over 30 years. Conclusion number 2, in connection with the development of Fisherman's Village pursuant to the lease, final judgments were entered into separate suits to quiet title, City of Punta Gorda, Florida versus C.C. Morgan et al., case number 76-684 on November 10, 1976, in Official Records Book 542, page 469, and City of Punta Gorda, Florida versus C.C. Morgan et al., case number 78-327-JRA on July 17, 1978, in Official Records Book 580, page 275 of the Public Records of Charlotte County, Florida, both of which are incorporated herein by reference. Both final judgments are in favor of the city and terminate the rights of all unknown persons claiming under the heirs and successors of the original dedicator of the plat. Conclusion number 3, the city has held title to Mod Park and Cosby Park by virtue of one or more deeds recorded for a period of more than 7 years, and the public municipal non-park use of the property has been open and notorious for 30 years. Conclusion number 4, due notice of all vacations have been given as is required by law. Based on the findings and conclusions herein, staff recommends approval of the requested vacations as advertised.
Thank you. Comments, board? Comments from the proponent?
Thank you, Mr. Chairman. I'm Mike McKinley of the Wititsky Law Firm. We're here today on behalf of the petitioner. The vacation resolutions were prepared in connection with our client's obligations under the acquisition agreement that was entered into between our client and the city some 14 months ago. Any questions, we're prepared to address them. Thank you. How you do?
This is we haven't opened the public comment yet. Okay. You were finished, sir?
Yes.
Oh, okay, fine. This is now opening the public hearing. Anyone wishing to testify, if they please approach the podium, state your name. If you've not been sworn, Mary will be happy to swear you in.
Yes, sir, I do. Sir, and I have one handout for the board members I'd like to.
Absolutely.
Yeah, my name is Robert McQueen, and I'm a property owner within the platted trade union. My family has owned property within the platted trade union for over 110 years. On the original platted trade union, there were 20 waterfront parcels, and there's 370 acres in the entire plat. 14 of these have been changed. Road right-of-ways, 10 of the 20 park sites are gone. So again, as an owner in the trade union plat, I'm opposed to the vacation of the additional plats because I still own lots in there, specifically the Merrill Lynch complex. And the more you have reduced my access to my properties, is affecting my clients and affecting the value of the property. The city has come in, made 5 one-way streets within this area of regional plat trade union. They have vacated 14 roads, and we have 10 parks that have been changed. On your application and survey for this hearing, I'm reading from an application vacation. And it says, as of January 1st, 2004, Public Works will no longer recommend approval of the street right-of-way vacations recommended and for stormwater management. I was doing a project on Punta Park, and that's exactly what the city did to me. They would not let me close a street or an alley. I had to leave it there for future stormwater for the city. It says in here, a survey will be required. It must not be over 12 months old. The survey submitted on the application is almost 5 years old. The petition must be signed, quote, by the owners, 60% of the owners. I've been up to the city and asked them, show me the 60%. You have, in order to petition for a street vacation, you have to be an owner, be a simple owner. The application on this is Fishville. The owner of record is Fishville. I don't think that's correct. In vacating these roads and these plats, if you look at your map and your agenda package, you can see it's already been closed off to Rieta, no access. And you're coming in now and vacating it all the way up to my driveway on Maud Street. So I'm opposed to that. If you'll just look at all the streets that have been closed in the parks, you can see I can't get but one way to my driveway. And you're vacating the access to the Fishman Village up to that driveway. So my objection here was I'm opposed to it because of the effect that it have on the access to the property that I own within the trade plat. There have been many other vacations. I was never notified of a vacation because I was not the adjoining property. So as they've done these 10 or 12 or 15 vacations over a period of time, I was never notified. The only reason I was notified of this because I am a jointly property. Thank you.
Thank you.
Good afternoon.
Yes, sir.
My name is Kevin Russell. I'm an attorney. I have been sworn. I'm here representing Nancy and Robert Trevue. Nancy and Robert Trevue are heirs of Isaac and Virginia Trevue. As Bucky's just provided you, Isaac Trevue formed the town of Trevue, which later became the city of Punta Gorda, and dedicated the parks in question and many other parks to the city for park purposes. My clients as heirs are concerned about the city's historical treatment of parkland dedicated by Isaac to the city for use as parks and converted for private purposes and private benefit. As Bucky just said, half the parks are now gone. While my clients have numerous concerns regarding issues not pertinent to today's hearing, it is important that I bring to you at least two matters that I think are. One, it is the family's position that the applicant lacks the fundamental ownership right to request a park vacation. I think as Ms. Tubbs pointed out to you, at least the claim is that this land is owned by the city of Punta Gorda, but ATA Fishville is the applicant. And therefore, they are not the proper applicant, as they do not own the fee under the dedication. And to that, I would cite you to Florida Statutes 177.101, paren 3. The second point I bring to your attention is that if the park is vacated, and if the park is sold, the proceeds of any sale of any park must go to park purposes. And I don't know if the city has considered that, but again, I reference Florida Statutes 95.36. As a result, the family would request that you proceed slowly and cautiously when considering this request. I should point out that the family has no animosity towards the Fishkill project. It is just the historical treatment of the parks as dedicated by Isaac Trevue and the conversion of them over the course of time to private use, and this is continuing that trend. We believe it's contrary to law, and it is ill-conceived as it applies to the city and the taxpayers. Thank you.
Thank you, sir. Thank you, sir.
Good afternoon. My name is Derek Rooney. I'm an attorney with the law firm of Gray Robinson in Fort Myers. I have been sworn.
Thank you.
I understand you had a long day, so I'm going to try and make this brief. Kevin stole most of my thunder. I also represent some of the Virginia and Isaac Trevue heirs, specifically Gary and Nikki Brockhorst and Caroline and Martin Lowe. And to be clear, my client also does not have any specific objections to the ATA Fishkill project. The concerns are related mostly to the historical use of the parks, the acquisition of the parks by the city, and what effect those rights may have on other parks and reverters contained throughout the city. As Mr. McQueen pointed out in 1885, there were 20 parks along the waterfront dedicated, set aside for public use. There are 10 now. In the city's findings, finding number 4 of the staff report states that the parks were never accepted. However, this is contradictory to the 1976 and 1978 city complaints to quiet title on Maud and Cosby Park. At that point, the complaint, the city argued that it both accepted the parks in 1896 by ordinance number 35 of the city of Punta Gorda, but also acquired it later in 1929 by virtue of some undisclosed proprietary right. Regardless of which of these methods of acquisition was utilized, it's clear from the city records and its own admissions that the title history is unclear, and I'm sure that's part of the reason why we're here today, in order for them to move forward on this project. In its quiet title actions, the city also argued that the parks were nevertheless acquired, had never been utilized for park purposes, and therefore had been acquired through adverse possession. While it is true that local governments can acquire property through adverse possession, they cannot use that as a mechanism to sidestep the Florida and federal constitutional requirements for just compensation. Now, I've made a number of public records requests when this petition moved forward, trying to determine some of the history on this project. I've not received all of those. Some of them came in today, so I apologize that I cannot go further into those issues, but we are concerned about this, and I understand that it's unfair to the applicant and you to have this 130-year-old factual situation dropped on you at the last minute. I know this is scheduled for next week. All that my clients would ask is that we take some time, allow us to get the records and look at them and see whether or not this affects any of their other rights, which is really the concern of Trevue heirs. Thank you very much.
Thank you, sir.
Sir, I've got one other comment. On this handout I gave you, shows all the lots within the plat. They all had a riparian right to the waters of Charlotte Harbor. So you'll see now, as they've been vacated, that we no longer have that riparian right, which Trevue kept in the plat when he did the plat. And my understanding is, from the attorney, Eddie Tisky, the only reason that they needed this park space was for 75 park spaces. Well, that's not our problem. Thank you.
Thank you, Bob.
It sounds to me that what you're being asked to do is undo what apparently courts have done a number of years ago, based on whatever evidence was presented at that time, which I'm not privy to. Don't even know if those records exist anymore, because it well exceeds the time for retaining some of those records. And all we have to go by is what is in the records today with respect to the outcome of those court cases and the deeds that are of record. I have not ever independently done a title search of Fisherman's Village. Have not done a thorough examination of the reasons why the courts decided the way they did. This acquisition, in the acquisition, it's the responsibility of the buyer to make sure that they're going to get clear title. And so they perform a title search, and they go through all the records. And if there is anything that would prevent the city from giving clear title under the terms of the agreement, then they have an opportunity to ask the city to clear whatever title defects might be out there. When I was presented with the title opinion based on the review of the record title, I did not even perceive any requirement from the opinion that I read of a need for this vacation resolution. And I think that the title company, and I wrote the attorney for Fishville of my opinion with regard to that. Their title insurer, nevertheless, I believe, wanted to make sure that, in abundance of caution, that we vacated particular rights of way that they're referring to. It was put into the agreement that that would be the obligation of the buyer to request that of the city. But since the city is a party to this matter, and since the indications were that the city did have full title, not just an easement right, but a full title to the parks and rights of way in question, that there was no need to go through what would be the typical route of having a owner petition for the vacation when the city was already the owner. So the way I looked at this, it was a technical matter simply to make sure that the one last step that was requested by the title insurer could be accomplished for this transaction to move forward. Now, this is not the time to reopen any cases that were resolved years and years and years ago, and I don't have any counter evidence to counter the allegations that something was not done properly many, many years ago. So it is what it is, based on the record evidence that's been presented to us in court decisions and the title opinion that was provided by the buyer.
So, based upon
just sorry, I just didn't your microphone.
Oh, I'm sorry.
Based upon what was just said, it is then your opinion that the city does have the right to vacate these properties?
Yes, because in my opinion, the property already been vacated. So this is just to make sure that the record is clear with respect to who owns, who will be owning that land as this transaction is finalized.
So, another way to put that, in your opinion, we are not in a position of vacating somebody else's property that we have no right to.
That is correct. We, by all indications, and Mr. McKinley can correct me if I'm wrong, the city already owns the land.
If I may comment, Mr. Chairman, the background, all these title nuances that the two attorneys and Mr. McQueen have raised have already been litigated and relitigated and reviewed and re-reviewed, and they're really beside the point, in my opinion, of the board's business today. The question in front of the Planning Commission, as I see it, is it a good idea to vacate the portions of Maud Street and Retta Esplanade and to give up any claim of public park use to the portions of the property subject to the agreement that are designated or arguably designated on parks on the old 120-year-old plat that we all agree have never been used for any park purpose, but only for revenue-generating purpose. I know that's a long way around the campfire, but that's, in my view, what's before the commission today.
extremely brief. If the city owns the land, why is it not the applicant? Why is ATA Fishkill the applicant? Who does not own the land? We all agree on that. Why are they not the applicant? They're required to be the applicant under the statute. And that's the point. This didn't happen hundreds of years ago. This happened a couple months ago when they made application. We have the wrong applicant.
And I think I can answer that. Mr. McKinley, maybe you will do it.
But if you look at the picture up there, we own the red and the purple. Right now, the purple is owned by the city. So we already own probably the whole 60%. So there's no 60% issue. We're the adjacent property owner. We own and feed the lands in red.
And to answer the specific question, about the applicant, I think it is it's not really a consequential question. The agreement between the city and Fishkill at the time of the acquisition put the burden on Fishkill to move forward with the cost of advertising and everything else, so that the public wouldn't have to do something which might not have been necessary to do in the first instance. So, like I said, the way I have viewed this is it's a ministerial matter based on the record that has preceded this matter for quite a number of years. So, whoever might be the applicant is not going to affect the validity of the decision to vacate. That decision has always resided with the city council.
If I could just put a couple more comments on the record, Mr. Chairman. Mrs. Allen has reminded me that these deliberations will in no way affect Mr. McQueen's access. He'll still have the same access that he has right now.
That's not true. Look at your handout on access. I will no longer have access from Riel and a riparian right back to the waters of Charlotte Harbor. Okay. I got two other documents I'd like for you to give to you. One was a letter that the city clerk wrote in 1970 to the clerk in DeSoto County and the clerk in Manatee County, asking them for any ownership that may have been conveyed to Trading. And the answers back from all three of the counties, there wasn't. 25 years ago, I wrote exactly the same letter to the city clerk and asked her that same question about Cosby Park. And her comment was, city had no interest in it. I'll show you the picture of the copy. I'd like
to If you're going to be introducing anything as evidence in this proceeding, we'll be happy to send you copies back, but that's going to have to come directly to the city clerk at this time.
That's what I
You said you wanted them back, so we need to know what it is that you gave and put in the record. Again, this is not the time to relitigate issues that apparently have already been litigated and decided years ago whether or not the litigants agreed with the decision at that time. That's not our concern. Into the mic. Yeah, sorry.
Are we saying now that the vacating this property is part of the agreement to sale of the property that was sold to Fishkill?
And I want to be clear on this. The city did not contract to vacate the right-of-way. The contract provides that the buyer will request the vacation. The city obviously would have the discretion at some point to grant that request for vacation or to deny the request for vacation. They're not contracted to grant the vacation. What I have said, and at the time that this agreement was written, we did not have the benefit of the complete title history and title opinion. It was after that the city approved the agreement with all of the conditions that needed to be effectuated in order for the agreement to be finally executed. There was a provision in there that said that that the buyer would seek the vacation of those roads. At that time, it wasn't determined that that would be necessary or not because we did not have a full title history. As it turned out, after receiving the title history and the title opinion that was rendered by the title insurer, I did not think that it would be necessary to do the vacation, and I communicated that back to the attorneys. The attorneys didn't want to delay the finalization of their obligations under the contract, wanted to move to closing as quickly as possible, and decided to go ahead and give or ask for what the title insurer requested so that they can then insure their title. And so, as I view it, this vacation, while not necessary, is a ministerial act that would at least satisfy the requests of the title insurer to allow this to go forward.
So, Mr. McQueen.
The city does have the discretion to vacate a portion of a right-of-way that might otherwise serve the property. So as I understood Mr. McQueen's testimony, he still has access. Right. It just isn't the best access, at least in his opinion.
That's true. It's not as good access, but now once you vacate this, the only access I will have is out on the one-way street, which is Marion. Before the vacation, I could go back, after repairing right all the way to the water, I could go back and have access through it. Now, I don't have that. So you're definitely impacting the access to my property and it's affecting my clients when their customers don't have as good of access.
So if they gave you some cross-access, vacated the streets and gave you cross-access?
No, they're vacating up to my driveway. Now, if I came in and filed a petition back to you to vacate the rest of it, they wouldn't have access to Fisherman's Village. And the other thing is, once you do this, you're kind of setting precedent. If you're taking the park and selling it to Fishville for 75 additional parking spaces, Impact's going to come in next week and want the same thing from you. What are you going to tell them? Oh, we just did one of them, just exactly what he's doing. So, I mean, you got to look at the rest of them down the line, too. How about the people that live on the rim? They don't have any guarantee that the property won't be developed as residential. The city has no policy on real estate. I tried to get them last charter hearings to adopt some policy. Hillsborough County, for example, you can't get rid of it unless it's a referendum. But the city has no policy on real estate. And yes, it's going to impact the traffic and where, then they'll only have basically one access.
It is disingenuous to claim that the vacation affects the access to the property at the corner of Maud and Marion because Reddit does not connect at the east end. It's not physically there. This is theoretical access.
Look at the map I handed you. It shows every one of those roads going all the way
to
the water.
There's no physical access.
Every lot in the plat has physical access on the plat I gave you. Now we've started vacating like 10 of the parks and 13 or 14 of the roadways. No, we don't have access.
The facts here are very different, very distinguishable from all of the other parks in the city of Punta. You know, in Lashley Park, there was a different set of facts. The passive parks along the way, the active parks, those are all separate and distinct. This property has been the fishing pier and the fueling docks since time immemorial.
Let me also point out one thing too, because when under the common law of dedication, which is what was done back in the day when this plat or plats similar to this were dedicated. If there's nothing specifically addressing it in the language, It is the act of the owner of the property in recording this document is offering those roads and rights of way and parks and what have you as a dedication to the city, to the public, to the city, which may or may not be accepted in whole or part by the city. Now, I'm just saying theoretically, and I don't have any facts with respect to each and every street and what have you. But at certain points in time, the city council, within its discretion, if they took the position that they were accepting roads, had the right to vacate those roads under whatever law existed at that time. They also had the right to theoretically not accept certain roads, in which case they would have remained private. Now, I doubt whether there's much of that either. But for us to try to undo history and suggest that because something was vacated years ago, even though it was on this plat, is wrong, is in opposition to what the law is with respect to the rights of municipalities concerning dedications under the common law of plats at that time.
Unless there's any other comments or questions by the board, do we have a motion?
Well, I guess we go 3 rounds.
Unless there's any other input, we'll have a motion to close the public hearing.
Second.
We have a motion and a second to close the public hearing. All in agreement, signify by saying aye. Aye. Opposed? Carried unanimously. Now, do we have a motion from the board? Based on the evidence and testimony presented at this public hearing for item number SV0316, I find that this request is consistent with the City of Punta Gorda Comprehensive Plan and move that we recommend to the City Council approval of this request. There's a motion. Do we have a second? Second. A motion to a second. Do we have any further discussion? All in favor signify by saying aye. Aye. Opposed? Carries unanimously. Thank you. Okay. Moving on. No new business. No unfinished business. We have staff comments.
There is new business. There was an amended agenda.
I didn't get the new agenda. I'm sorry. I'm sorry. I didn't have the new agenda. Go ahead.
Pardon? Yes, it is. For the record, Joan LeBeau, Urban Design, and this is for informational purposes. The city is looking to make an application to the Florida Recreation Development Assistance Program for a trailhead. It'll be called the Street Trailhead at the Henry Street location. It's on Shreve Street, close to the History Park. This is administered by the DEP. It is a highly competitive grant, and it will be a 50-50 match. Next slide. As you can see, it is in association with the existing Punta Gorda pathways. Next slide. And here is a close-up of where the trailhead will be. It will be on the south end of the existing History Park. Next slide. We are looking to, this is a concept plan that we will be sending in with the application, and it will connect the pathways to the trailhead, meaning a regional component. It will have picnic areas and a restroom pavilion. The restroom pavilion will be made to look similar to those existing homes at the History Park. Next slide. We are looking at it being a picnic area for those who are using the Punta Gorda pathways.
We will be incorporating the type of furniture that is currently existing at the nature park. Next slide. And some of the opportunities that we have will include a grill, a bicycle parking area, and then additional benches. Next steps after this, so we'll be going to the Historic Preservation Advisory Board this Thursday. We are summarizing the public input that we received from additional meetings that we have had. We did have a public input meeting that was slightly well attended, and we'll be sending our application in by this Friday. We will not hear if the work was announced, was awarded to us until 2018. Are there any questions? Yes.
John, it's happened before, and now it's happening again. I believe this was already approved by City Council. And now it's coming to us, an advisory board, post facto. Why? I partially mean this. Why waste our time? It's one of those things that, I have input on this, but it doesn't mean a thing. Because it's a fait accompli. And I objected the last time, and I would like to go on record again, that I object this time to things coming to this board for advice when they will have no input on City Council.
We needed to, in order to move forward, we did need to have input from council to make the
But you don't have input from us then. I mean, that's my point, and I'm sorry I get angry over it because, I know it's been a long day, and this was kind of put on as an additional surprise to the agenda, and it's taken up time that I really would be better spent doing something else.
Thank you, John. Can we blame that on Howard?
For the record, Terry Tubbs. In order for staff to apply for any grant, City Council does have to authorize staff to apply for the grant. The additional meetings are to obtain the public input, which is why it was put on the Planning Commission agenda, as well as the additional going to the Historic Preservation Advisory Board. Staff is not allowed to even consider putting in the time to apply for a grant unless City Council gives that authority.
I would like to just say that I did attend a meeting last week about the Trailhead project, and it was very clearly explained. I think that it's something we need to move forward with, and I would offer my support to go ahead and apply for the grant.
Thank you. Thank you. That's it, Joan? Okay. Unfinished business. Hearing none, staff comments. CRA status report was attached to the package. Does the board have any comments or questions about the committee or board comments? Citizens' comments. Hearing none, adjourned.